Re Selectmove 1995. Selectmove had got into arrears with the Inland Revenue regarding payment of PAYE that was owed. A tax inspector had agreed with the company that they could pay off the arrears by instalments. While they were doing that, the Inland Revenue petitioned for a winding up of the company. Re Selectmove argued that, in fact, the Inland Revenue had made an agreement that they could pay by instalments. So on appeal, the court held that two important issues. The tax inspector had no authority to make any such agreement, but that even if he had, there was no consideration for that promise to make payments by instalment. Selectmove tried to rely on Roffey and Williams and said so long as there was some practical benefit, it should be, that promise of the Inland Revenue should be enforced. But the court pointed out that the case they were relying upon, Roffey Brothers, applied only to cases where work was done or goods were supplied. It didn't apply to late payment and paying off debts, and that Folks and Beers had held that even if there is a practical benefit, that won't be good consideration in that situation. And since Folks and Beers was a House of Lords case, the Court of Appeal made a decision that, in fact, the Inland Revenue could go back on that promise and collect the full amount and could be granted the winding up petition.